Hello, a very warm welcome to the third in the Landmark Chambers series on planning High Court challenges. In today's seminar, we focus on substantive law. And during the course of the next 2 hours or so, we're going to cover many of the cases that have filled our diaries and the issues that have occupied our thoughts over the last year or so. We're absolutely delighted to see so many of you joining us today. My name is Melissa Murphy, King's Counsel, and I'm going to chair the session today. I'm joined by my colleagues Richard Turney, King's Counsel, Matthew Henderson, Nick Grant, Joel Semakula, and I will formally introduce each of those speakers in a moment. To begin with, just a few housekeeping points that I've been asked to mention. Your microphones are automatically muted, so you don't need to adjust your local settings. We very much welcome questions throughout the session. You can submit them in the box at the very bottom of the screen saying Q&A. We've got a lot of attendees, so it will inevitably just be a snapshot of your thoughts, but we'll answer as many as we can. The webinar is going to be recorded, and you're going to receive a link to the presentation and the recording shortly after the event concludes. If you lose your connection at any point, just rejoin the meeting by clicking on the original link once more. As to introductions, I'll introduce each of the speakers at the very outset before we hear from each of them in turn. By way of an overall introduction first, each of us is a barrister at Landmark Chambers, and each of us specialises in planning and environmental law, but the balance between those two mainstays of our practice varies as between each of the speakers. So that's the overall introduction. By way of the detail then, Matthew Henderson will speak first. He is a 2016 call. He's been involved in a number of important and in fact useful cases over the course of the year. C.G. Fry, for example, Keep Chisnall Green. Local plans work has kept him in God's own country this year too, promoting local plans. And he's in fact also worked on a number of nationally significant infrastructure cases too. Joel Semakula will speak next. 2017 call. He's had a busy year too, and he tells me he's been enjoying working on the promotion of the Tottenham Hotspur Women's Training Facility in Enfield, which sounds pretty good to me. And as well as a variety of housing inquiry cases and development consent order examinations and judicial reviews. We'll hear next from Richard Turney, King's Counsel. Richard, prior to taking Silk, was on the Attorney General's A panel of counsel. He's consistently highly ranked in all of the relevant guides and directories and has an enviably broad practice across the planning and environmental law specialisms, I think with a particular emphasis on infrastructure, nationally significant infrastructure matters. We're then going to hear from Nick Grant, 2016 call. He is ranked for valuation as well as planning and environmental law specialisms, and he is also on the Attorney General's panel of counsel, B panel. He's been involved too in a range of very significant cases, including Fry, Finch, Mull Valley Greenbelt case recently, and CBRE Kent, about which we are going to hear later. And as for me, well, I love an inquiry, and I have been very privileged to have done some amazing, memorable ones over the course of the years. Bramsill, for example, West Ferry. I represent a variety of developers and national organisations. I also like being in the High Court. What I do now that I've picked up a bit of planning over the last 20 or so years, it's less terrifying. I also have something of a knack for promoting sensitive and strategic scale sites. But enough about me. Now is time to hear from Matthew Henderson on the latest NPPF case law. Part one, please.
Hi there, Melissa. Thanks very much for that introduction. So my talk today is a partner talk with Joel. I'm dealing with part one. Joel will deal with part two. And between us, we will cover a series of cases over the last 12 months dealing with the NPPF in various different shapes and form. Now, in respect of my talks today, I've got four cases together. First is C.G. Fry, second Mead realisation, so the first of those in the Supreme Court, the second in the Court of Appeal, and then two in the High Court, Dorchester Living and Edith Weston. The theme between these really are the limits of national policy, but also the flexibility of national policy. Fry is a case about what the NPPF or national policy cannot do. It cannot make material a factor which would otherwise be immaterial. Dorchester is something of an illustration of the limits on national policy. On the other hand, Mead realisation shows the breadth of national policy, in particular its flexibility as a tool to guide decision making and the ability of the PPG to interpret, elucidate or even to amend the NPPF. And Edith Weston is a case in a similar vein, dealing with the interaction of national and local policy and the ability of national policies to steer a path through an otherwise restrictive local policy context. All of this is particularly important now in November as we approach December, for the Secretary of State promising a new NPPF in time for Christmas, but also the Secretary of State's recent indication about national development management policies. They are going to be non-statutory, difficult, I suspect, to distinguish from national policy in provenance or in application, and not on a statutory footing. So all of the issues of national policy, interpretation and application that I'll deal with and Joel will deal with in our case law roundup, all of those problems are going to persist yet further once those national development management policies come into play. The first then is C.G. Fry. Now this is a case principally about the habitats regulations, but ground two, which is the ground that I'll focus on today, was of particular importance because of the NPPF in paragraph 194. And I've put paragraph 194 on the screen there. And the relevant part of 194 is 194 subparagraph B. Now, B deals with the protection of proposed Ramsar sites, whether they're listed or proposed, I should say. And what it does is it applies the Habitats Directive and the regulations, the Habitats regulations in domestic law to those Ramsar sites. So ground two was specifically concerned about this limb of paragraph 194 of the framework. The facts are well known now, it's quite a well known case, but it's a case about the discharge of conditions imposed on an earlier reserved matters approval. Those conditions were about trees and other matters entirely unrelated to the Ramsar site in question, but the discharge of those conditions had been refused on the basis that no appropriate assessment had been undertaken, and it wasn't possible to conclude that there might be or might not be an adverse effect on the integrity of the Ramsar site. Ground one dealt with the habitat regulations and their interpretation and was specific to matters of European sites, so European sites as defined in the habitats regulations. Ground two, by comparison, was dealing with Ramsar sites specifically, and this part of national policy which applies the habitats regulations in circumstances where they otherwise would not apply. So the question for the court is essentially, could the NPPF apply the habitat regulations in those circumstances where the regulations themselves were of no application? And the answer to that was no. The framework couldn't go that far. It couldn't make material what would otherwise be immaterial on the facts of that case. Why was that? Because the grant of outline permission, whether it's the outline permission here or indeed a full plan permission, conveys with it a legal right to develop in accordance with that permission and subject to compliance with the conditions that are imposed on that permission. And that right to develop is not defeasible depending on government policy on any particular day or week. And therefore, although the local planning authority has to look at the discharge of conditions and look at those carefully and specifically, the ambit of that decision is tied to the ambit of the condition. So the discharge of condition is confined to matters which are fairly related to the subject matter of the condition, and it would be impermissible to bring into that consideration matters which are not tied to that subject matter, so extraneous matters. Here, when dealing with a tree condition, matters going to the trees, protection of the trees, the impacts on trees, all relevant to the discharge of the condition. Impacts on the Ramsar site, not relevant and not a permissible consideration. So the application of this important for Ramsar sites, but actually really significant for a great deal of developers on a number of sites up and down the country, because of the need to have a specific focus on the condition and for the local planning authority to make sure that its consideration is specifically direct to the subject matter of that condition. This keeps on cropping up time and time again. It's happened quite a lot recently, for example, because of new flood mapping and local planning authorities a sense of uncertainty as to what degree that can or can't be brought into account when something is changed from the position at the time of the grant of the outline permission or the full permission. And the answer in all of those cases, clarified by the Supreme Court under Ground 2 and Fry, is that you've got to focus on the specific words of the condition, the specific ambit of the condition, and only take into account those matters which go to that specific condition. Now, of course, we're familiar, the Newbury Wright case law and the House of Lords, the Supreme Court, material considerations being those that are fairly and reasonably related to the permitted development. And Fry really is a continuation of that, but focusing in more narrowly. So at the outline or the full plan permission stage, of course, taking into account all those matters, including in this case Ramsar sites, because they're fairly and reasonably related to permitted development. But at the condition stage, that focus has got to narrow what is fairly and reasonably related to the condition in question. And the NPPF cannot change the law on that basis, however strong the wording of paragraph 194, subparagraph B may have been. So that's the first of my cases. Second of my cases is Mead Realisations. It's a case in the Court of Appeal. It deals specifically with the sequential test in the NPPF and the role of the PPG in elucidating that policy. The relevant part of the NPPF is paragraph 174, and I've put that up there. Development should not be allocated or permitted if there are reasonably available sites appropriate for the proposed development in areas with a lower risk of flooding, so the sequential test, as we refer to it. And the PPG, paragraph 7 of the relevant part, gives specific guidance on what is a reasonably available site. It deals with a number of factors. For example, it doesn't need to be owned by the applicant. It could be made up of 2 or more smaller sites. And this is something which you don't find in the NPPF. The NPPF is in broad terms, fairly high level, as the quotation that I put at the top of the slide shows, but the PPG goes into a lot more detail. Now, the specific facts of that case were fairly straightforward. The inspector, although there was compliance with the local plan policy in respect to the sequential test, the inspector dismissed an appeal on the basis that he considered there were reasonably available sites by reason of there being a number of smaller sites that were adequate for meeting the specific residential development that had been proposed in the application. And the inspector based his conclusions of what a reasonably available site was or was not in that case on that guidance in paragraph 7 of the PPG. And the inspector felt that that paragraph elucidated to him how you should be applying the sequential test as you see it in paragraph 174. Claim for statutory review failed in the High Court, and there were 2 issues for the Court of Appeal. 2 broader issues. First issue is whether the PPG can amend the NPPF, and the second issue on the facts of the case here was whether the inspector was wrong to find that the PPG elucidated the sequential test as it set out in that sentence of paragraph 174. The appeal was dismissed on both grounds. So on the first issue, Court of Appeal held that PPG can, in principle, amend the NPPF. Why? Well, it has the same legal source, same legal status as the NPPF. There's no distinction between the PPG and the NPPF as a matter of law, although as a matter of practice and in terms of policy, there is a distinction. The PPG is presented by the Secretary of State as having a supporting role, to use a sort of broader term. But even though there's that presentation, it doesn't, as a matter of law, prevent or distinguish between the two, and therefore there is no reason in principle why the PPG could not amend the NPPF. And indeed, we've seen this in a number of cases with WMSs making amendments to the NPPF, but on the PPG specifically, no bar. Why is that important? Well, it's the power of policy as a tool to shape decision making. The PPG, as we know, is much less formal than the NPPF. It's updated without consultation, can change without notice. It's a web-based resource. It's flexible in its composition, has a mixture of policy and guidance. For some areas, a lot of detail. In other areas, very limited detail. And therefore, it's a powerful tool that can be deployed to achieve aims in here to really give quite specific direction on the application and interpretation of policy, which the NPPF does not otherwise contain. So that's issue one. Issue two was about the inspector's approach. Had the inspector looked at paragraph 7 of the PPG in the correct way? The answer to that was yes, he had. There was no inconsistency between the words of paragraph 174 and paragraph 7 of the PPG. Both of them were consistent with each other, and a lawful judgment had been made on the facts of that case as to what was or was not a reasonably available site in the particular local area. So that's the Court of Appeal in Mead. The next case that I'm dealing with is a case called Dorchester Living. Now, this is a case dealing with a challenge to the grant of planning permission on appeal. Somewhat unusual circumstances. Housing Land Supply in two parts to be read cumulatively. One part in one development plan document dealt with the needs of the local plan authority for its own area. The second part in a different development plan document dealt with the needs of a neighbouring local plan authority, which this particular local plan authority was to take on and to meet. And both were intended to be read together. The problem was one of those, the first of those development plan documents being for the needs of the area specifically, that was more than 5 years old, but the more recent development plan document dealing with the neighbouring area's needs was less than 5 years old. Now, that's not a position covered by the NPPF when it comes to calculating housing land supply. Paragraph 78, which I've put on the screen there at the top of the slide, deals with it in fairly straightforward terms. LPAs identify and update annually supply specific to local sites to provide that minimum 5 years worth of housing against their housing requirements set out and adopted strategic policies, or against their local housing need where the strategic policies are more than 5 years old. Issue here, of course, two policies, cumulative housing requirement, but on both sides of the 5 year threshold. What was the answer? Well, the inspector took a fairly pragmatic view. The inspector took the local housing need for the area specifically, so used the PPG and the standard method to calculate that. And then to that, she added the requirement from the second, not yet out of date development plan document to produce a cumulative overall need. And it was against that cumulative figure that she assessed housing land supply. Now, the challenge was based on an alleged misinterpretation of paragraph 78 of the framework, and specifically how you interpret those words that are underlined. Was it a need to use LHN alone? Was it LHN plus the DPD on a cumulative basis, or was it some other approach? And Mr. Justice Leven dismissed the challenge on a straightforward basis that the NPPF will not cover all scenarios. And in those circumstances, it's a matter of judgment for the decision maker. And in this particular case, the inspector had reached a rational judgment that accorded with the underlying policy of the framework to take into account the needs of the area that had not been met. It's highly fact specific. You're not going to encounter this very frequently, but it does go to two wider points. The first, and this happens more and more often in the context of housing appeals, is that it's not at all uncommon to have unusual scenarios where the way in which a housing requirement has been calculated, or the way in which it's been put forward on appeal, doesn't fit neatly within the terms of either paragraph 78, the footnote 39, or indeed the PPG. You've got cases such as Tewkesbury dealing with oversupply, cases like East Riding dealing with plans which are about to be replaced or about to become out of date. And each of those cases, Tewkesbury, East Riding, and now Dorchester Living, pragmatic approach of the High Court, understanding that policy won't cover all scenarios, there are limitations to national policy, and leaving it over to the judgment of the decision maker, in each case the inspector, based on the underlying policy imperatives. Then the final case that I'm dealing with is a case called Edith Weston. A recent case Plan permission granted for development by an inspector on appeal in conflict with a freshly made neighbourhood plan. There was an agreed error. The inspector had gone into a bit of a muddle about what status the neighbourhood plan had and how far through the plan making process it had reached. And the inspector treated it as a material consideration rather than as part of the development plan, which it should have been. That was an agreed error, although on the facts, ground one, the judge held that error would have made absolutely no difference, and therefore that ground was dismissed. But ground two, which is of more interest for today's purposes, goes to NPPF paragraph 14. This was a site which was within a neighbourhood plan area, and within that neighbourhood plan area, the neighbourhood plan itself had no allocations. But there were allocations within the core strategy which went to those areas, and the neighbourhood plan sought to build on those allocations by setting quite detailed design and other criteria against which to judge any allocation and any application on those allocations as they came forward. The issue is whether that policy, that sort of design, placemaking policy was enough to be an allocation for the purposes of paragraph 14b. So you see those underlined words contains policies and allocations to meet its identified housing requirement? And the answer to that is no, it wasn't. The framework means what it says. When it says an allocation, it means an allocation. It doesn't mean some other support and policy which might go to an allocation in another development plan document. So again, just stepping back, what's the theme here? Well, the theme here is about reading the framework in a straightforward manner, but it's also about the force of the framework. The force of the framework to set clear boundaries and for those boundaries to be properly followed by a decision maker, in this case dealing with neighbourhood plans and the contested issue of housing allocations in those plans. So stepping back, Fry, the limitations of national policy. So to Dorchester living, we can't cover for all circumstances, but on the other hand, and perhaps of particular importance as we move forward with national development management policies on a non-statutory basis, cases such as Mead and Edith Weston, the flexibility, the breadth of national policy, the ability of the Secretary of State to introduce it easily and indeed specifically, but also with a particular objective in focus. All of those matters are ones which we're going to have to be dealing with, both of the new NPPF before Christmas and then national development management policies in the new year. So they're my four cases, and I'm going to hand over now to Joel, who will look at part two.
There we are. It works. Thank you very much for that, Matthew. So I am going to be looking at 5 more cases. And there we are, the screen's changed. Thank you very much. So I'm going to be looking at Mole Valley, Save Wimbledon Park, Stoke Mandeville, Hilltop Experiences, and Ticehurst. And I think Nick's also going to be looking at Ticehurst in a bit more detail a little bit later in the presentation. So let's start then first with Mole Valley. This was a case in which the claimant council challenged the planning inspector's decision in February 2025 to grant retrospective planning permission for a material change of use from rural land to house residential and touring caravans for the Gypsy traveller community in the Greenbelt in Dorking in Surrey, and to quash an enforcement notice against the same. Now, the inspector's decision there and the court's judgment in this case involved interpretation of revised planning policy, in particular the updated NPPF, that being the one in 2024, and the planning policy for traveller sites, both also published in December 2024. As well as introducing the concept of grey belt land, the updated NPPF introduced a new exception whereby development of the Greenbelt should not be regarded as inappropriate where specific criteria were met. Now, in this case, the inspector found the land to be grey belt under the 2024 NPPF and that the proposal met paragraph 155. He treated the development as not inappropriate and concluded that the Greenbelt was not harmed, so very special circumstances were not engaged. Now, Mole Valley District Council here brought a statutory challenge, And ground one of that challenge, alleged misinterpretation of NPPF paragraphs 142, 153, 155, and footnote 55, effectively arguing the inspector wrongly excluded harm to openness from the balance once development was found not inappropriate. Now, the key issue for the court here was whether the inspector had erred in law in concluding that the aim of greenbelt openness cannot be compromised by development that is not inappropriate. The council's case was that paragraph 153 requires substantial weight to be given to any greenbelt harm, including to openness, in any planning application. And they argued that footnote 55 merely removes the requirement to give substantial weight for certain categories, but does not bar decision makers from giving some weight to openness harm, even where that development is not inappropriate. Now, the court held that on a proper reading of paragraph 153, it must be read in the context of the Greenbelt chapter here as a whole. And effectively following Lee Valley, the court held that development that is not inappropriate is not to be regarded as harmful to openness or to Greenbelt purposes as a matter of policy. The court also made it clear that, in addition, footnote 55 is clarificatory in that it confirms that where development is not inappropriate on PDL or Great Belt land, the policy requirement to give substantial weight to any harm, including to openness, does not apply. So it's not a halfway house here, permitting some weight to be given. The point is that once development is not inappropriate, openness harm is not engaged. Now, in this case, there are arguments made that later authorities on openness had displaced Lee Valley, but the court rejected those arguments. The distinction between inappropriate and not inappropriate development remains central and of general application under the latest NPPF. So in these circumstances, ground one failed. The judge here clearly noted that to interpret the policy in the way that the council sought would undermine the purpose of the new exception for grey belt development, the intention behind which was to permit development that would not previously be permitted. And considering and giving weight to possible harm, even where a development would not otherwise be development, had the potential, the judge thought, to hamstring this policy change in an unintended way. And I think a point of procedural interest here is that technically, the judge refused the claimant authority permission to make an application for statutory review to the High Court under Section 288 of the 1990 Act. And it followed then, by reason of practice direction, the practice direction relating to the citation of authorities of 2001, that the parties required the judge's permission to cite the judgment before any court. And Mr. Justice Chowdhury indeed gave that permission in October of this year. The next case I want to talk about is the widely publicized Save Wimbledon Park judgment. Now, the claimant here brought a claim challenging the Mayor of London's decision to grant planning permission to create 38 new tennis courts, a stadium, and related buildings and infrastructure, expanding the current site onto land at Wimbledon Park Golf Course. The expansion land is designated as Metropolitan Open Land and a Grade 2 star listed registered park and garden of special historic interest. The land itself is subject to restrictive covenants, requiring it to be kept open and free of built development. Now, Save Wimbledon Park also argued the land was held subject to a statutory trust for public recreation. The claim here advanced three grounds. The key ground that probably received the most news related to the lawfulness and rationality of the Mayor of London's approach to the materiality of the assumed statutory trust over the development site and the restrictive covenants affecting the development site in the determination of the planning application. But I'm not going to deal further with that ground here. For present purposes, I'm focused largely on ground two, which challenged the approach to paragraph 202 of the NPPF, that being deliberate neglect or damage to heritage assets. Save Wimbledon Park here alleged that historic land use decisions, principally the long-standing golf course layout and associated planting and management, had caused deterioration to the registered park and garden, and that this should be treated as deliberate neglect or deliberate damage. Their argument was that the erosion of design landscape features and legibility of historic planting was the culmination of owner interventions and therefore deliberate, with the corollary that heritage benefits claimed by the applicant should be discounted. The claimant here further contended that officers had failed to grapple with this policy constraint, instead treating remedial works as freestanding benefits within the heritage balance. The court rejected that ground. It held that the decision maker had the issue squarely in mind, that the officer's report had recorded SWP's reliance on paragraph 202, identified the current significance of the registered park and garden, and explained that erosion arose from lawful management choices inherent in the golf course use, much of which predated listing. So on a proper interpretation, the court held, deliberate neglect or deliberate damage requires a conscious decision to run down or harm the asset. I mean, the policy's purpose is to deter owners from intentionally degrading assets to improve prospects of consent. Lawful, long-standing management that incidentally diminishes the significance is not deliberate neglect or damage. And the absence here of any concern, particularly from historic England and other statutory consultees, reinforced that conclusion. Accordingly, the court here held that paragraph 202 of the NPPF was not engaged. The decision maker was not required to disapply the deteriorated condition of the RPG or to discount the heritage balance, and there was no obligation to descend into further analysis once it was rationally concluded that intentionality was not evidenced. Now, in my view, this is significant for two reasons. First, it reminds us again that paragraph 202 imports an evidential threshold of intentionality, so mere attribution of adverse effects to owner decisions without proof that something more is insufficient. And it also confirms that the lawful pre-existing uses and their routine management, even if they erode elements of significance, do not trigger the 202 proviso. If we go there, then looking at ground 3 as well, the claimant also argued that the NPPF paragraph 103's exceptions, which I'll deal with again shortly, should be read there through the lens of community health and access, contending they do not accommodate commercial stadia, and that the decision failed to address quantitative losses of open space, focusing instead on qualitative gains. But here the court confirmed a straightforward reading, really. The exceptions in paragraph 103 of the NPPF are disjunctive. There's no textual exclusion of commercial sports provision, and alternative sports and recreational provision can be satisfied by schemes substantially for sport recreation assessed holistically. So for these purposes, ground 3 was also dismissed. Now we'll return to paragraph 103 shortly. Turning now to the third case, that's Stoke Mandeville Parish Council. Now, this is an application for judicial review of the decision of Buckinghamshire Council to grant permission for the redevelopment of Buck Sports and Social Club to provide 100 residential units. The claimant here was the Parish Council, which opposed the application and which had, in February 2024, submitted a bid to purchase and operate the site. The club was owned by the council and had been disused since June 2018, but was identified as an asset of community value in August 2020. The issue related here again to the proper interpretation of NPPF paragraph 103, to which I said I'd return, which provides policy protection for existing and former sports facilities. Officers advised here that the site was not existing, formulating a rigid test of current or quite recent use. And members were also told that there was no conflict with NPPF paragraph 103. Now, under ground 1, the Parish Council contended that this was an error of policy interpretation. NPPF paragraph 103C expressly refers to the loss of the current or former use, confirming that policy protection is not confined to facilities in active use. The council ultimately accepted that existing does not mean in current use, but argued application was a matter of planning judgment. Now, under ground 2, the Parish Council argued it was irrational to conclude the site was not an existing facility, given maintained pitches, a mown cricket square, and goalposts, and said officers illogically treated the pavilion and fields as an indivisible unit. Now, the council here maintained that whether a facility is existing is a matter of planning judgment, permissibly informed by the prolonged cessation of use and the condition of buildings. Now, in this case, ground 1 succeeded. The judge held that officers materially misdirected members by applying a rigid current, recent use, or easy reopening tests that the words in the policy do not bear. There's also a local plan policy here in effectively the same language. They said that correctly construed, existing does not require current use. NPPF 103C's reference to former use confirms the broader protection, and the advice that NPPF 103 was inapplicable was a material error. However, ground two failed here. The court confirmed that determining whether a facility is existing involves planning judgment, not a bright line temporal rule, and it was lawful to consider the long period of non-use and to assess the fields and the pavilion together. The maintained appearance of the pitches here do not compel a contrary conclusion. And so here we're reminded, of course, that the proper legal interpretation of policy is logically prior to planning judgment. And the court here, of course, made clear that existing sports facilities protection extends beyond active use, consistent with NPPF paragraph 103C. Fourth case, next, I want to talk about Hilltop Experiences Limited. This claim relates to Norfolk County Council's decision to grant planning permission for a household waste recycling centre within a designated AOMB, which was challenged by the claimant. Now, the claimant here runs an outdoor education facility for children approximately 30 metres from the site, and a proportion of the children have special educational needs and other vulnerabilities. The proposed recycling centre is a replacement for an existing household waste recycling centre facility on a site almost adjacent to the one for which planning permission was granted. The claimant here brought the judicial review on 6 grounds, one of which was withdrawn. However, for the purpose of this talk, I'm only going to focus on grounds 2 and 3, which pertain to the definition of major development under paragraph 183 of the NPPF, which is set out there on the slide. You see what we're talking about now is paragraph 190 in the new NPPF. Now, under ground 2, the argument was that the officer's major development analysis took into account irrelevant considerations, calling the scheme essential infrastructure and noting proximity to an existing household waste recycling centre, and that properly directed, the proposal should have been found major given the site size, equipment, throughput, and asserted adverse impacts. Now, ground 3 proceeded on the assumption the development was major, contending that the authority failed to undertake the exceptional circumstances and public interest analysis required by paragraph 183, including an adequate appraisal of need, alternatives outside the designation, and harm. On ground 2, the court reaffirmed that major development for paragraphs 182 to 183 is a matter of planning judgment under footnote 64, focusing on factors such as nature, scale, setting, and the potential for significant adverse impact. Now, references to essential infrastructure and the existing household waste recycling centre were immaterial, and the decisive factors, the fact it was a small site in the household waste recycling centre terms, there was limited throughput, adjacency to a main road and an existing household waste recycling centre, and the LVIA's minor to moderate adverse findings made the non-major conclusion here rational. Now, the development management procedural order definition of major for validation processing purposes is not determinative for NPPF paragraphs 182 to 183. And on ground 3, because the proposal was lawfully found not to be major, the paragraph 183 exceptional circumstances and public interest test did not engage. In any event, the court found the officer correctly identified the policy tests, members were experienced with AOMB policy, and the paragraph 183 considerations are context-specific and non-prescriptive, consistent with authority. The court found that had there been any omissions, those would have been immaterial, given the non-major conclusion reached earlier. Now, the court in this case did not explicitly consider what the implications of the 2015 DMPO definition are on the relevant NPPF paragraphs, but it seems that its acceptance of Norfolk County Council's conclusion implies that although major development within the DMPO 2015 includes waste development, all waste development will not automatically amount to being major development for the purposes of 183, now paragraph 190 of the NPPF. And finally, I want to talk about Ticehurst. Now, this case concerned a judicial review of Rother District Council's decision to grant permission for a carbon negative live work unit at Beach Farm in Sedlescombe within the Highwold AONB. Officers twice recommended refusal, identifying conflict with the development plan, AONB harm, and an unsustainable location. On redetermination, the planning committee nevertheless granted permission, resolving that the scheme was innovative, not isolated, and that its benefits outweighed potential harm to the Highwold, concluding it was sustainable development under paragraph 11D of the NPPF. The parish council advanced 3 grounds, including misapplication of paragraph 11D. The claimant argued that the proper application of paragraph 11D required a sequential approach. First, Lim 1 with the footnote 7 policies to determine whether AONB policy provided a clear reason for refusal, and if not, Lim 2, the tilted balance. It said that the committee neither identified applicable footnote 7 policies nor demonstrated that it gave great weight to conserving and enhancing the AONB under NPPF paragraph 182. And in any event that it failed to conduct the Lim 2 balance lawfully. The court here held that on paragraph 11D, while the committee did not spell out a step-by-step recital of Lims 1 and 2, in substance, it actually applied them. The officer's report and advice repeatedly directed members to paragraph 11D and to paragraph 182. And on that basis, the committee can be taken to have considered whether AONB policy gave a clear reason for refusal and concluded that it did not, before proceeding to the tilted balance. And looking at the 182 question, really that AONB policy point, the court held the committee was properly reminded of the Great Weight requirement and of the Section 85 duty in the Countryside and Rights of Way Act 2000. The law here doesn't require the phrase great weight as an incantation. What matters is that the reasoning shows that it was applied. And the committee's focus on AONB harm and benefits satisfied that standard. So here, the judgment reinforces the fact that decision makers need not necessarily recite paragraphs 11D1 and 2 verbatim, provided their reasoning, read together with the officer report, shows the correct sequence and engagement with the relevant footnote 7 policies. And it confirms that paragraph, of course, 182 is a footnote 7 policy, and great weight must be given to AONB harm, but that may be outweighed by benefits as a matter of planning judgment. And so that's where we'll leave it there. So that's it from me. I think next we have Richard.
Good morning, all. I'm going to address some of the case law on under the Planning Act 2008, challenges to nationally significant infrastructure projects and to national policy statements. I am in part going to go beyond that because some of the cases are concerned with matters that touch on those things but aren't directly concerned with that type of challenge. Could you move on to the next slide, please? I'm having difficulty controlling them. Thank you. So the structure that I'm going to take is, first of all, pick up some of the key themes in the case law over the past year. Then I'm going to look to some likely future areas of challenge. And then finally, I'm going to look at some reform that might be in the offing for this type of challenge. Next slide, please. So these are my key themes from the case law from about this time last year until now. First of all, assessing and evaluating greenhouse gas emissions against relevant policy tests. And really, this is a sort of what happens after Finch point. That case obviously has pronounced on the need for greenhouse gases to be assessed in terms of downstream emissions. But the fundamental question for decision making is, what do you do with those assessments? The next point is a point about fairness and the way in which major infrastructure is consented, and dealing with 2 points there, really. First of all, the growing prevalence of other policies which determine the scale and location of particular infrastructure policies bearing on the planning decision-making. And secondly, various cases about how ministers actually reach their decisions. And then the final theme is the relationship between the 2008 Act and other regimes. Firstly, in respect of emerging and novel technologies, and how far do we look at other consenting regimes? And secondly, a particular point about solar development and the thresholds between these Planning Act 2008 decisions and the Town and Country Planning Act decisions. Next slide, please. So greenhouse gas emissions in practice. The first case I was going to mention is Boswell, which is a name which is quite familiar as the name of a claimant. I don't think anyone has necessarily totted up the number of claims that Mr. Boswell has brought or been involved in, but certainly this is one of them. This 2025 decision of the Court of Appeal concerns the net zero Teesside proposals, which are for a new gas-fired power station with post-combustion capture of carbon dioxide. And the issue there, which fell to be considered by the courts, was about the CO2 emissions, greenhouse gas emissions arising from that proposal, because although post-combustion capture is planned and integral to the proposal, the assessment was that about 5% of the emissions would not be captured, and obviously 5% of a very large amount of gas is still a lot of carbon dioxide. The essence of the claim was that because the Secretary of State had considered those emissions as a significant adverse effect in the planning balance, he also should have concluded that they were effects which put net zero, the government's net zero objective, at risk. And the rationale for that argument was that the IEMA guidance, the technical guidance on how to assess greenhouse gas emissions, said that a significant adverse effect is an effect which puts net zero at risk. And the question posed by the claimant was, how could you both conclude there was a significant adverse effect and that you didn't jeopardize net zero? The answer given by the High Court and indeed by the Court of Appeal is that national policy is not that prescriptive. The IEMA guidance is just that. It is referred to as the basis of assessment in the national policy, but it's perfectly lawful to conclude that the overall contribution does not jeopardize net zero, and indeed that the proposals would promote net zero objectives, but the residual emissions would nonetheless be significant and adverse. I think my overall comment about this case, something of a surprise that it got through the permission stage, both in the High Court and into the Court of Appeal. But perhaps the learning from that is that there are legs in greenhouse gas emissions points, even for projects which are expressly being promoted as necessary to achieve net zero, such as this one. The next case to mention is the Transport Action Network case. So this is one of a series of challenges to national policy in respect of roads, and in particular a challenge to the designation of the national network's national policy statement. And the issue was, the underlying issue was this: should the Secretary of State, in adopting the national network's NPS, rely on the sectoral plan for decarbonising road traffic? And it was a challenge that then took flight through two sets of arguments, one of them about the duty to give reasons in deciding to adopt a policy in a particular form, and secondly, an argument that there should have been further consultation because of changes made between the draft and the final version of the document. I think what we learned from this is that the court effectively was endorsing the rationality of a decision to rely on the sectoral decarbonisation plan for roads. And this is important because, of course, that is the theme of national policy statements and indeed wider national planning policy, that it may not be necessary to look in detail at the carbon emissions that would be generated by particular schemes because of a plan to decarbonise the whole sector. And for roads, that's a particularly critical point, because if the government's position as it is that in 15 or 20 years, emissions from road transport will be materially or indeed wholly addressed through sectoral decarbonisation. The construction of roads is not in itself going to lead to increased carbon emissions beyond the construction impacts themselves. So this is effectively an endorsement of the position that has been taken, albeit through the lens of a public law challenge to a consultation. There was no need to give additional reasons for concluding that the transport decarbonisation plan could be relied upon. The next case on this is the High Knot case. And really the question there was about how should emissions be approached on multi-phase schemes. And just to explain briefly what this was about, the witty name of the claimant company gives away that this was a challenge to the HyNet scheme, which is a large-scale scheme for the production of hydrogen and the capture of carbon dioxide from industrial processes and its storage in depleted gas fields in the Irish Sea. And there are a number of components to the wider scheme. There's a development consent order for an onshore pipeline, planning permissions for works to existing gas terminals, spur pipelines, and so on. And then here, a permit under the offshore EIA regulations for storing the carbon dioxide in those gas fields in the Irish Sea. This is a permission decision, so it needs to be treated with a bit of care. But in it, Mr. Justice Saney held that it was lawful not to assess the entire scheme's CO2 emissions, and that the assessment could rationally be limited to the offshore scheme. He said it was wrong in principle to conflate different projects which may form part of a larger network, such as the HyNet cluster, and to suggest that the effects of one project fall to be considered as if they were effects of another. And that's a good example of the court taking a relatively robust approach on what is a cumulative effect of a particular scheme. Here, it was found that it was rational to say, no, the project before me is the offshore project. It is the pipeline under the sea. It is the deposit of the gas in the CO2 in the depleted gas fields. It is not all of the other consents that lead to the CO2 getting into the pipeline in the first place. So perhaps a useful steer from the courts about how to approach cumulative greenhouse gas emissions in this sort of context. Next slide, please. So these are a couple of cases about fairness and how can decisions be made fairly in the infrastructure field. The first case, Safer Waters, is not a challenge to a development consent order or a national policy statement, but a challenge to the approach taken to a water resources management plan, and in particular, the decision of the Secretary of State to proceed with the water resources management plan process without holding a hearing or inquiry. And this concerns in particular the water resources management plan for Thames Water, which includes a proposal for a new large reservoir. The interesting dynamic here for major infrastructure projects is that once a water resources management plan is in place, for the purposes of national policy statements, the need for that project has been shown, and the options that can sensibly or lawfully be taken forward by the water company will to some extent have been narrowed through the adoption of a water resources management plan. So the argument goes, well, by the time I get to a development consent order examination, I can no longer be heard on the question of whether or not there should be a reservoir in Oxfordshire or indeed in other places where those strategic options are preferred. The past has been sold, that need question has been determined, and it's unfair in those circumstances for me not to be heard on that question at the management plan stage. The court rejected that argument. It was recognised that there was a power to hold an inquiry, and indeed there was an inquiry on one of the previous water resources management plans, which led to the exclusion of a reservoir in Oxfordshire from Thames's plan some 15 years or so ago. But the question of whether it was required on the facts as they stood today was a matter of judgment for the Secretary of State. There was independent specialist advice from the Environment Agency, as well as from Ofwat and Natural England, as well as written representations. And in those circumstances, it was fair to proceed without a hearing or inquiry in the adoption of that plan. I think this is an important point and potentially a theme for future challenges, because the Water Resources National Policy Statement is not the only place where we get the idea that previous policy decisions, earlier policy decisions, might determine or be highly influential in the outcome of the development consent order application outside of the National Policy Statement process. A good example, the emerging centralised strategic network plan for electricity transmission, which will identify where large-scale transmission is required and also therefore make the need case when such schemes are promoted through the DCO process. The next set of cases are concerned with slightly more mundane fairness arguments. Save Stonehenge, everyone will know, is the A303 Stonehenge challenge. And one of the issues considered by the Court of Appeal is whether in redetermining the application following the first quashing, did the Secretary of State have to go back to hold an independent examination? The answer was fairness did not require that on the facts. And I flagged that case not perhaps because of its particular legal sophistication, but it is a bit of a cause célèbre amongst the government. It is a case where the government considers that the judicial review process has stopped the A303 Stonehenge tunnel rather than just delaying it. And I'll come back to that in a moment. Dawes was a challenge to the Manston Airport DCO, quite an interesting little procedural wrangle. The examining authority had before it a report called the Azimuth Report, which was based on anonymized information from interviews with airport and flight specialists. And those experts' views had been anonymized into a report, and there was a refusal to disclose the underlying interviews which had informed the report. Now, the examining authority said, well, as a result, we're not going to give very much weight to a need case that is made on the basis of this type of report, and recommended refusal. The Secretary of State disagreed, said that weight could be given to the Azimuth report, and accordingly decided that development consent should be granted. The question, the fairness question, was should the Secretary of State have gone back to the relevant, all the interested parties in that case and said, look, I'm proposing to disagree on this point. What more do you say about it? And the answer was no, that wasn't required on the facts of the case. Although there is a power to do so, the Court of Appeal found, and that power applied, on the facts, it wasn't necessary to revert because essentially it was a question of weight rather than a question of disagreeing on matters of fact. It was about how to weigh the evidence and not take into account a new fact. The final case on this slide is the Immingham case. Now, the Immingham case, which I'll come back to on the next slide, is concerned or was concerned with a challenge by operators of an oil terminal on the port of Immingham to a decision to grant development consent to Associated British Ports for what's called a ro-ro terminal, a roll-on, roll-off ferry terminal. The focus of their objection was on the effect on navigational matters within the port of Immingham. And one of the arguments was the Secretary of State, Louise Haigh, had shown apparent bias through visiting ABP's facilities before her appointment, and by writing a letter which seemed generally supportive of the port and its expansion. The court held no, that did not amount to apparent bias, and that was just part of the normal world of politics, where politicians will express generalized views and they will engage with matters such as major infrastructure in part of their routine job and can still fairly determine implications. Next slide, please. So here I am back on the ABP proposals in Immingham. I've already explained the background to the case. The first ground there was concerned with the extent to which the Secretary of State for Transport had relied on the Harbour Authority's control over navigation. And the dynamic, of course, is that ABP is the Harbour Authority, as well as being the applicant, or at least a subsidiary was the applicant. In the environmental statement for that case, there had not been an assessment relating to risks occurring in respect of vessel movements, and that was the thrust of the oil terminal operators' concerns. And useful decision-making here, again from Mr. Justice Saini, in respect of the Gateshead principle. And he summarised at paragraph 48 that principle, which I'll just summarise or use his summary here. Firstly, that planning decision makers are entitled to have regard to regulation outside of the planning system. Secondly, there's no requirement to duplicate such controls, which are often the responsibility of expert bodies and regulators. And thirdly, the decision makers should generally assume these regulatory processes will operate effectively. That's the Gateshead principle as it's become known. It's also dealt with by the Court of Appeal in Tash. So there's a whole line of authority, but it's a useful encapsulation. One of the important points here was that the Gateshead principle justified a conclusion that the Secretary of State had adequate environmental information because there was no need to assess anything arising from the use of particular vessels and impacts on navigational matters, because there wasn't likely to be a significant effect, because that would be managed by the harbour master under the existing control. And therefore, the Gateshead principle effectively is justification for excluding that matter from the environmental assessment. Fordham is a similar case, and that was a decision to the Semakula solar farm. Again, it's a permission decision, so treat with a bit of care. The issue there was battery safety and whether the decision maker, the Secretary of State, was entitled to assume that the COMAR regime would deal with any matters relating to battery safety, fires arising from hazardous substances in the batteries, if and when a COMAR consent was sought and obtained. And the answer was that the contrary proposition was unarguable. It was not necessary for the Secretary of State to decide that matter in the application for development consent. The final two cases I'll take very quickly. They're both concerned with solar, and they're concerned with issues that arise about the scale of solar farms. Now, everyone will be aware of there being a rush of applications over many years for 49.9 megawatt solar farms to get just below the DCO thresholds. And there are some issues which arise from that. Ross is one of those cases. Ross is concerned with the question of overplanting. So this is where a solar farm proposes more solar panels than are necessary to meet the grid export agreement. In other words, what has been agreed as the overall capacity to provide power to the grid. And overplanting is proposed often because of the risks of degradation of solar panels and so on. And of course, the effect is that if you overplant, you end up with more fields of solar panels than you need on day one to meet the grid objective which you're trying to meet, which is giving a certain amount of power to the grid at peak times. And Ross effectively provides some significant clarification on that point. It considers that although it's necessary to consider overplanting as a planning matter, what is reasonable overplanting. It is just a question of what is sensible or appropriate, and it's a fact-dependent assessment, noting in that case that the proposal for overplanting was sufficient. It was not necessary to consider in detail whether that overplanting was justified by detailed scientific analysis of degradation and so on. Drayton Manor is the last of those cases. Again, it relates to solar farm, and this is a slightly strange procedural point in terms of the way these things come to court, but we might see more of it. So Stratford upon Avon granted planning permission for schemes for an amendment and changes to an existing Town and Country Planning Act solar farm, so sub 49.9 megawatt solar farm, but noted that they were concerned that the two grants together, the earlier and the later, meant that what was proposed was a nationally significant infrastructure project and therefore required development consent under the Planning Act 2008. And as a result, Drayton Manor went off to the court and sought a declaration that what they were proposing was not an NSIP, because if you propose an NSIP and start to build an NSIP, you commit a criminal offence unless you have development consent for it. The court found that what was proposed was not an NSIP, but it does show a slightly interesting procedure here, which we may see more of, where it's the court that's invited to determine whether or not the proposal is for an NSIP, effectively because that is not for the local planning authority to determine. If you make an application for something which may or may not be an NSIP, that is not a matter for the local planning authority. That is a risk that you take as the developer. And accordingly, Drayton Manor had to go to the court to get the clarity that what they were doing would not amount to the commission of a criminal offence. Next slide, please. So leaving the case law of the past year or so and that whistle-stop tour, I just wanted to flag a few areas where I think future challenges may emerge. The first one, I think, is the review of the airport's national policy statement. That process is ongoing, and it seems to be likely, I'll put it like that, that whatever decisions are made, that there will be at least consideration of whether there are grounds for a challenge there, given the history of Heathrow expansion and the propensity of those opposed to it to bring legal challenges. Greenhouse gas emissions. I think there's still another turn of the page on this. There is some very interesting material coming out from the European Court of Human Rights and from the International Court of Justice in respect to the human rights relevance of greenhouse gas emissions. And in particular, there's a very recent decision of the Strasbourg Court called Greenpeace Nordic. And this is the first time that the Strasbourg Court has waded in to environmental impact assessment and what that should be assessing in respect of greenhouse gas emissions. So, of course, we've got loads of EIA material from Luxembourg, but Strasbourg hasn't yet grappled with it. And Greenpeace Nordic is the first time it does so. And effectively, it's finding that there is a need to properly assess the impacts of greenhouse gas emissions there from oil extraction proposals, oil and gas extraction by Norway. But effectively, there is a need to assess to meet those Article 8 obligations, which have been articulated in earlier case law. The next one is what I call green on green challenges. So in particular, in the offshore space, there is an increasing battle for space and for wind and for other resources. And I think it's likely that at some point in the coming years, that's going to spill over into a more litigious sphere. And then I've put there strategic water resource proposals. That's effectively picking up the safer water points. But also, I think that there's a similar issue arising in respect of energy transmission that I've already touched on. Final slide, please. So what's next as well? I think for me, the big flag is that there is a sense in some of the commentary that we have from government, in particular from Treasury, that impacts of delay on projects through challenges, and in particular delay to nationally significant infrastructure projects, that there is unfinished business here, that the changes, modest as they are, that have come through to date are not sufficient. There was a Lord's amendment to limit the scope for such challenges. There are concerns about the speed and expedition of those challenges, and there is a direct consideration of whether ARHU's protections should be amended or removed in respect of such challenges. So I think this time next year, it's likely that we'll be talking about reforms to the way in which nationally significant infrastructure projects can be challenged, rather than just about the outcome of those challenges. That's all for me. I will hand over to Nick.
Thank you very much, Richard. So I'm picking up on the new protected landscapes duty, i.e. the one that was inserted by section 245, I think, of the Levelling Up and Regeneration Act. So prior to the LURA amends, the protected duty, whether it was in the Countryside and Rights of Way Act for AONBs or National Parks Act for national parks, required relevant authorities to have regard to various statutory purposes. I've put the AONB one on your screen. LURA amended that so that the requirement is no longer to have regard to those statutory purposes, but to seek to further those statutory purposes. And it's the cases that are discussing that which I'm going to speak about today. So the first off the mark was Ticehurst, which Joel has already spoken about in some detail. It wasn't a particularly significant point in that case, but in the course of delivering his judgment, Turney KC indicated that if the Section 85 1A duty, that's the new duty in the Crow Act for AONBs, is performed, the authority will inevitably give great weight to conserving and enhancing AONB landscape and scenic beauty. So that's just a small point, but that was indicated that he wasn't saying that it was sufficient if you do give great weight to discharge the duty, but he's saying if you perform the duty inevitably in the planning balance, and local authority, a decision maker will have given great weight. The first detailed consideration came in the New Forest case, and a lovely picture of the New Forest on your slide. Now, this was an application for a grant of planning permission for an extension to a dwelling. The inspector in that case had found there was no harm to the character or scenic beauty of, in that case, it was the national park. And there were two grounds put forward. One was about the misinterpretation of local policy. I'm not going to pick that up today. But the other was about the failure to discharge the enhanced duty in Section 11A 1A. And this is really the first detailed consideration, and is still the most thorough detailed consideration of this new duty by the High Court. And it's a judgment of Mr. Justice Mould, the planning liaison judge, someone intimately familiar with planning law, so authoritative. Mr. Justice Mould started off by noting what's not controversial, that changing have regard to seek to further is inevitably a strengthening of the duty. But the wording stops short of there being a requirement to actually fulfill statutory purpose. It's a duty to seek to further, not a duty to actually further. And what the court said is you must consider first whether the development is consistent with the promotion of the statutory purposes. And if not, if it would undermine those purposes, then there needs to be a consideration of whether, and you need to explain why, permission should nevertheless be granted. And that will come inevitably by considering things like the size and scale of the development, the extent and severity of the conflict with the statutory purposes, and any mitigation and compensation and conditions that can be imposed. Now, as this was a national parks case, one of the duties was to seek, one of the statutory purposes is to conserve and enhance scenic beauty of the national park. So we got some useful guidance from the court on what that means, and effectively the judge said, conserve means do no harm. Now that'll be familiar to many of you from the heritage context, because that's the same, and in fact it was heritage case law that the judge inevitably drew on in formulating his understanding in this case. He also said the and is disjunctive. So whilst it says conserve and enhance, one of the arguments that was put forward by the claimant in that case is you have to consider both whether it does any harm to the national park or AONB, and then whether it also enhances it. And the judge said no, and is disjunctive. It is sufficient if the proposal does no harm to any of the purposes. You don't also have to go on to determine, or the decision maker doesn't have to go on to determine whether it would enhance it. You do, however, need to consider both purposes generally. So how will the court act on any review? The judge said very clearly that whether the duty has been discharged is a question of substance, not form. So effectively, we're not looking at, and this will be familiar from certainly some of the other presentations we've heard today, not looking at some sort of magic word express recitation of I have had regard to section 85(1)(a) or section 11(a)(1). It's not fatal at all if there's no express reference to the duty. In effect, what the court is going to require you to do is to look at the reasons actually given and then to disclose whether there is a substantial doubt about whether the duty has been performed. And it's for the challenger to show whether there is a substantial doubt. So in this case, for example, the inspector made no reference at all to the test. But on the facts and on looking at the reasoning in some detail, the court held it was discharged. The inspector had actually very carefully considered whether the proposal would conserve and enhance the natural beauty. And as I said at the outset, the inspector had held it would, that fundamentally in this case, there would be no harm to the national park. And he didn't, the inspector, go on to look at the second purpose. But the court said, well, on the facts of this case, it was not any party's case that there would be harm to the second statutory purpose. So frankly, the inspector's reasons didn't need to deal with that. So in the end, the court upheld that decision. So we'll go back now to the High Weald, which has been a case that was touched on in Ticehurst already. And this claim, Kent, CPRE Kent, and the following, the Wadhurst Parish Council case, which I'll come to talk about in a moment, were issued and pleaded very shortly after New Forest, or indeed it quite possibly they were issued before the New Forest judgment came out and then responded to after the New Forest judgment came out. There's a very, very short overlap between them. So this was CPRE Kent concerned the development of 165 homes in Cranbrook within the High Weald AONB. Now, this is the Turney case. Some of you may be familiar with the saga of it, because frankly, it was one where we hadn't appeared the inquiry back in 2020. The inspector said grant, Michael Gove said no, that got quashed, and then it got redetermined. Angela Rayner said yes, and this is the challenge to that decision. The Secretary of State had accepted there would be some harm to the landscape and scenic beauty of the AONB in that case, but nevertheless granted permission. And two grounds were put forward by CPRE. First, that this Section 85 duty positively required the Secretary of State to refuse permission, and second is reasons. And ground one's possibly the most interesting one, because effectively the argument that was being run was the new Section 85 duty. It fixes your discretion. If you're in a situation, the claimant said, where there is any residual harm at all to an AONB, you have to refuse, because otherwise you're not seeking to further the purpose. There is a route to furthering the purpose, which is open to you, and that is refusal. And if you don't do that, then you haven't really sought to further the purpose. That's what they said. And during the course of the hearing, it became quite clear that the argument, in fact, went much further than that. And bear in mind, AONBs, national parks and the Broads cover between them about 25% of the country. And during the course of some of the judges' questioning, the argument that you had to refuse, it fixed your statutory discretion, went further, because the CPRE also accepted effectively the proposition that the same would apply in the enforcement context, i.e. local authorities would have to enforce. And in fact, it went further still, because of course, if you've got something already established, development like a power plant or what have you, that is still harming or giving harm to the AONB, of course, you've got discontinuance orders in the Planning Act. They're rarely used because they come with the liability to pay compensation. And the judge said, well, isn't this also fixing your discretion to have to issue a discontinuance order? And CPRE were obviously relatively uncomfortable with that, but there wasn't really an obvious way to refuse or to rebut that point. So it effectively would have stymied and in effect required the removal of development over 25% of the country. And when its full implications are understood, the judge had no qualms at all about rejecting it for all those reasons. Again, it's another judgment of Mr. Justice Mould, and he effectively reiterated his approach to be taken in the New Forest case. Now, obviously, that was one where there was no harm. This is one where there was harm. But he said that the approach in New Forest paragraphs 60 to 63 still apply. It's not the case that the only rational, reasonable conclusion open to you once this duty applies is to refuse if there's any harm at all. The implications are vast. The language is to seek to further the purpose, not to actually further the purpose. And also when, where there are examples in legislation where if that outcome is intended, it's said in terms. The habitats habitats regs is a clear example and one that weighed on the judge's mind. That says you must not grant a permission, consent, what have you. Section 85 1A or A1 doesn't do that at all. So for all those reasons, ground 1 was rejected in no uncertain terms. Ground 2, in terms of the standard of reasons, there was an argument, less so from CPRE Kent, but there was an intervener in that case for their campaign for national parks, and they were implying that there was a higher or more difficult standard of reasons, not said so expressly, but certainly implied, when the Section 85 1A duty applies. Mr. Justice Mould rejected that. The standard of reasons is South Bucks, which we are all, of course, familiar. And again, this was an exercise by the judge in effectively going through both the inspector's report, which had been drafted before Section 85 A1 came into effect, and the Secretary of State's decision, which had been drafted after it came into effect. The Secretary of State's decision did refer to it. There were a number of forensic points taken by the claimant, but fundamentally the judge went through and all of the key building blocks of the New Forest requirements. Is there harm? Yes. Why should permission nevertheless be granted? Here's all the analysis of the minuscule level of harm, the fact that this is a proposal that offered a vast amount of public benefit. The harm is actually pretty self-contained within a small visual envelope, and all of the mitigations and compensations that are in place. All of that was discussed and considered, and the judge said that on the facts and substance, the duty had been discharged. Wadhurst Parish Council, same AONB, National Landscape, sorry, the High Weald. Now, this was a challenge to two permissions, one for a material change of use of land and the other to establish some yurts at a campsite in Buell Water, which is a picturesque reservoir. Wadhurst Parish Council didn't run the same argument that was being run in the CPRE Kent case on ground 1, but they were running reasons challenges on a question on ground 2, sorry, about whether the inspector asked himself the right question. Now, Wadhurst and CPRE Kent were heard at the same time. They weren't joined, but they were heard at the same time over the same couple of days, and then judgment published shortly after. And the reason Wadhurst is important is although the inspector does make reference to Section 85 A1 in the decision letter, there isn't a New Forest paragraph by paragraph breakdown, or for example, a breakdown going through each of the New Forest tests. And again, there was an argument about whether the inspector had asked himself the right question, because a lot of the analysis was based on looking at things like the underlying policies and the High Weald AONB management plan. The judge rejected the challenge. He basically, again, it's a question of substance, not form. And the inspector, having gone through detailed analysis of the management plan and all of the matters that conserved and enhanced the AONB, had very clearly formed a view on whether there would be harm, which is the first step in the New Forest test, and then looked very closely at why permission should be granted. So again, this was one where, even in the absence of paragraphs explicitly addressing New Forest, the substance was that this had been done by reference to the extant local policies and plans. And that, I think, is an important point and a key takeaway for those in this space, or if you've ever got a planning application or a decision where Section 85 is in play. 2 points is, one, it can be helpful if you want to include an explicit couple of paragraphs on each of the questions posed in the New Forest case, probably at the end after all the other analysis that you've done, because that just puts the point beyond any doubt that you've considered it. But two, if you don't, then it's certainly not fatal to a decision if in substance you have asked yourself and gone through and asked yourself all the right questions, whether or not you mentioned section 85. So we leave the beautiful High Weald and wander up now to the beautiful Lake District for a slightly more nuanced and discursive discussion here, in as much as this was a decision to grant planning permission for using the slate caverns at a former quarry for heritage tourism. So there would be things like zip lines and rope ladders, and people come and look around. It was effectively a tourist space. And what was being argued in ground one was that the duty was vitiated by a legally erroneous approach to the Sandford principle, as advised by a senior member of the committee. And then there was an attempt to amend and introduce ground 1A, which said that the defendant heard in law in its interpretation an application of the Sandford principle. So this is the first time Sandford comes up in the section 85, or it's National Park, sorry, section 11, 1A context. But what is the Sandford principle? So I mentioned at the top of this segment that both national parks and AONBs have a number of statutory purposes. The national parks one is on your slide, and they're to conserve and enhance natural beauty, wildlife, and cultural heritage. That's the first one. Second one is to promote opportunities for understanding and enjoying special qualities by the public. A new section 11, 1A, which I've repeated here and underlined, says that if there's a conflict between those purposes, greater weight must be attached to the purpose of conserving and enhancing natural beauty, i.e. the first limb. So that's the Sandford principle. It's been considered in previous case law, which makes clear that it only comes into play where it's not possible to treat both purposes equally, and it's not possible to accommodate both purposes through management or stewardship. And these are all questions of value and value judgment, primarily for the decision maker rather than the courts. So on ground one, the officer had advised there would be some degree of harm to cultural heritage. There was a discussion between the committee members as to the Sandford principle. It had been stated correctly. And then a committee member had said, arguably, opening the site enhanced the cultural heritage, that's limb 1, as it introduced visitors to an aspect of the Lake District's heritage often underplayed. And what was being argued was that actually that conflated the purposes. If you're talking about access to the national park, that's limb 2. The committee member had misunderstood it. She was an experienced committee member to whom a lot of people had regard, and therefore it showed the committee erred. Now that was dismissed. Fundamentally, the court said the principle had been correctly outlined. Senior committee member didn't demur from that. She was just arguably indicating that there could in fact be a degree of harmony between the purposes and they weren't in conflict, and that's a perfectly lawful thing for her to have pointed out. So there wasn't a conflict, Sandford principle wasn't necessarily engaged, and there certainly wasn't a misunderstanding of it. Ground 1A was that the officer had concluded there would be some harm to cultural heritage by changing the perceptual character of the quarry. So she concluded it wouldn't further the first purpose. But she did say it would further the second statutory purpose by offering public access to a heritage asset. The officer had overall decided that even applying great weight to the first purpose and great weight to conserving heritage assets, where there might be some harm, the harm overall would still be outweighed by the benefits. And the claimant argued that that's not right. They said that the first purpose had to always be given preference over the second purpose, so that was a misapplication of Sandford, and the court said, no, Sandford requires applying greater weight to the first purpose, but it doesn't mean it must always prevail. It's basically the claimant was running a similar type of argument to CPRE had done in CPRE Kent case, which is there is this fixed outcome which you must adopt because that's how you give. That's what greater weight or furthering the purpose requires. And the court said, absolutely not. Yes, you might put greater weight in here and lesser weight in here, but fundamentally, it's a large evaluative judgment for the decision maker. So where does this leave us? Well, it's a useful application, a useful discussion of the Sandford principle, and both between Friends of the Lake District and CPRE Kent. It's a pretty clear example that the court is resistant to the idea that there is only one rational outcome when you get given these broad balancing duties in, for example, Section 85 or Section 11. The idea that therefore they mandate an outcome unless it does so in the clearest possible terms, like the habitats regs, the court really isn't on board with. So that is it from me on this, that whistle-stop tour of the new duty, and I will now hand over to Melissa.
Hello again, everybody. The sequential test in recent cases. Over the years, I realise I've spent quite a bit of time advising on and arguing over, in fact, the sequential test in both retail and flood risk cases. And while recognising the very good sense in prioritising sites within the forward planning process and making provision for something equivalent within the development management process, I've nonetheless found it clunky and unsatisfactory in practice. It's difficult to satisfy. So little wonder that it has occupied time in the courts as well as at appeal, and we see that policy and guidance has been revised in turn as a result. I'm just going to go back to my slides. There we go. So clunky in practice and difficult to satisfy. Hence wanting a haiku to ease our passage from our introduction into flood risk generally on the theme of raindrops and surface water. Now, Lucky Saint is alcohol-free or near enough, so you can do so without guilt. We begin with the engagement of the sequential test on our slide proper. Prior to this amendment, we had the rather anomalous position whereby even when a site could be made safe, taking into account climate change risk, without increasing risk elsewhere, the sequential test was nonetheless required. And since there are real and I think practical concerns about passing the sequential test, whether or not it is engaged is really significant in the process of managing and minimising risk to the planning process. Certainly one would prefer to undertake testing, you know, if one's primary case is that the sequential test is not needed, and so you're offering it for comfort, if you indeed offer it at all. So that question of engagement then is very important. And so this exception then, if you look at it, is really about a sequential approach at site level. So thinking there about land assembly and development design. So that NPPF change brought us back to the previous orthodox position where if you had no flood risk in reality, then you've got no harm, and therefore you're not looking for alternatives. The part of the policy that has not changed, you can see, is the consequence in policy terms of failure. So you can see that this is, as I put in parentheses at the bottom, a policy directing refusal. But what is it? Well, by its nature, it is itself a policy, and so it is a material consideration within the planning decision. We're going to come back to the import of that very shortly when we're looking at some of the case law. Guidance first. here I'm going to be, I'd like you to reflect on what Matt Henderson said about the need realisation case. Remember that the Court of Appeal judgment was handed down in January 25, and this PPG update is in September 2025. So hence you see on reasonably available sites the match between them. So that's why it's worth just linking those two parts of the seminar. In terms of specific changes, other changes, you can see reference to surface water risk. And it seems to me that this is creating a wider exemption than the NPPF paragraph 175 exemption as it relates to surface water. So that is well worth thinking about. I'll say a little more about reasonably available sites. The first point is that the area for search remains judgment-based, albeit in the context of more detailed guidance. The second is that it is able to meet the same development needs, and as I've indicated, it seems to me that that reflects need. Now, that previous slide, as you've seen, that I was linking the change to guidance to a case you've already heard about. Now, I'm going to link change to guidance to legal principles about which you're going to hear more in a moment. But just for now, just note the reference to planning balance in this new bit of guidance. So it's telling you that the absence of a higher housing land supply is not relevant consideration in applying the sequential test. It comes to the application of the sequential test in a moment. However, housing considerations, including housing land supply, may be relevant in the planning balance alongside the outcome of the sequential test. So that's important. Reference to the planning balance in this flood risk context, and that explicit reference essentially acknowledging its status as a material consideration of the planning balance. Now we're about to move from flood risk to retail. And again, we're going to do that by way of a further haiku, gentle transition. And I like this because, well, I thought it was relevant to retail, the town centre, but also that sticking with the theme of water through the town centre, a little stream flows bordered by weeping willows, lovely. And here too, on retail, into the nuts and bolts of it, the content is unchanged on this. And what I'm asking you, inviting you to consider, is that this too, just like in the flood risk context, we have a policy directing refusal where you've got failure of the sequential test. So on our case law now, we've got three areas for our investigation. Firstly, as we've seen, those policies directing refusal, what does that then mean for decision making? Secondly, the need for the sequential test to be applied. Really, this is about its engagement. And then thirdly, the application of the sequential test. So policies directing refusal, this is the West Berkshire case, and I'm afraid an inescapably wordy slide, and also the quote is rather gendered. The point though, if you just take a beat to look at it, so your policymaker is entitled to express an opinion in unqualified terms, but it doesn't have to incorporate an exception as part of itself. The point being that however it is worded, by its nature, a policy which is directing refusal, it must be one factor, one material consideration among others, albeit, as we'll see in a moment, it can be a very important one in planning balance. We see that principle applied in the Astor Stores case, again, retail context. you can see the reasoning. It is a material consideration. Where an application fails to satisfy the sequential test, it should be reviewed, so that's the policy. Wherever a decision maker finds breach of the policy, this will count as a negative factor with the force of government policy behind it. It will go against the proposal as material consideration. But however it is worded, it cannot mandate refusal because it remains a question of planning elements. And so it is of interest then to see the PPG on flood risk amended to reflect that legal position. And there is a forthcoming case which touches and concerns that very matter. It's been heard in the planning court quite recently. It's one of mine. We've got the judgments awaited on it, and it is black in the flood risk context, based on Asda and West Berkshire. And the point which is taken by the claimant based on Asda, and as I say, West Berkshire too, the failure of the sequential test is a material consideration, and the refusal cannot be mandated by policy. So I hope that it is helpful to you to know to look out for that. I then turn to the need for the sequential test. Now, I've included this. There's a pair of cases here, substation action, and then we'll see what and find in a minute, because they were decided at a time when the policy position for including the NSIPs was equivalent to that which pertains now, i.e. no requirement for the sequential test in relation to surface water where the development could be made safe without without increasing risk elsewhere, including in relation to climate change allowances. The point being that you would then expect to see the sequential approach being taken site development, sequential approach, and a planning judgment being needed about the acceptability of what has been done in that regard. And so we see that those cases then come back into view as important in terms of approach. So substation action and what implied for essentially the same reasons. And so the approach there, I'm contending, then is of considerable pedigree. What then about the application of the sequential test? Then we revisit our old, or by now familiar friend, or indeed foe, the available site. And I suppose it is just worth acknowledging that it can be a bit perplexing for the developer who, after all, is primarily interested in the promotion of one site, their site, having to consider others which are potentially have absolutely no interest at all, but hence the detail of what's required being really important. And the Court of Appeal in the retail context there found that the site is available. It is available for the development proposal, which I think is the same development requirements. So what's the theme here? Well, I suggest you are seeing the alignment of need realizations, in turn, September 25 version of the flood risk, PPG on available sites, and the retail context. So you've got an outbreak of happy agreement about what that language means, and then in turn how that text is then applied. So bringing it all together. Takeaway points. The flood risk changes to the PPG seems to me bring us back to the position as that substation action was implied. No requirement for sequential test in relation to surface water flood risk, where the site can be made safe without increasing risk elsewhere, taking account of climate change allowances. Secondly, on flood risk, you see the alignment of the meaning of available in these contexts. And then finally, and I think importantly, the failure of the sequential test is one material consideration among others, and of course now weight is the matter, axiomatic weight is the matter of the decision maker. And so we're left then planning, as in life, a question of balance. And if you're persuaded, not obvious, but if you're persuaded that planning and poetry belong together, then you can always follow me on LinkedIn. Now, if you had any questions, this would be a good moment for it. But my sense is that many of the questions have been answered on the way through. If I can ask others to join me by turning their cameras on, I'll pose one or two. Now, Nick, are you able to turn your video and your audio on?
Yeah, can you not see me? I'm showing up on my screen just fine.
I can see you just fine. Now, a question for you. Thinking about the new duty that you've been talking to us about, what's going to be sufficient to discharge it? Is it going to be sufficient to just accord weight to it?
No, I don't think so. I mean, there's a line in Mr. Justice Mauld's judgment that says in terms it's not sufficient to just accord weight in the planning balance. If you start getting into great weight, it might be slightly different, but fundamentally, I think it would be better and clearer to make sure that any document that's produced, whether it's an inspector's report or an officer's report leading to a committee decision, engages pretty explicitly with the questions posed in the New Forest case, paragraph 60 to 63, rather than just relying on the great weight provisions that are currently in the NPPF.
And another question for you, Nick. And putting it in the Highways Authority context in particular, is there any difference in those sorts of cases?
No, I don't think so. I mean, I'm not aware of any further cases that look at this specifically in the highway context. The duty is relatively new, so it's not unsurprising there's not a vast amount of case law out there. There is some guidance put forward by DEFRA, but there's no authoritative consideration at the moment, certainly not from the courts, on how it factors into, for example, choice of alternatives, which is obviously something that comes up in highways quite a lot. So it's just one area of risk at the moment. I think the best thing you can do is, as I say, engage pretty clearly with the New Forest questions. And if you're at a stage where you're looking at choosing between various alternatives, maybe apply those questions to the alternatives. And if you think one is still better than the others, even if there's, for example, a differential impact, explain why. And you need to properly engage with whether one is harming and the others aren't. And if you think the one that's harming should still be the proposed and the best one to take, that will need explaining why, looking at things like the degree of harm, the size of the scheme, conditions, compensation, and mitigation.
Thank you, Nick. That's really helpful. We've had a question on the search area for the flood sequential test, which I'm going to, which I'll take now. And thank you very much indeed for the question. I think it's a good one. I'll preface it, I hope in not too annoyingly a lawyerly way, by saying that we haven't had the practical workings out of this new guidance yet. And so, I suspect that there will be argument about some of this. But to answer the question, I'm asked about the area of the search with the sequential test, and really parallel to some of the greenbelt work that we've all been doing. The area of the search with the sequential test, as I said a little earlier on, we've got some really quite detailed guidance. It's now contained in PPG 27A within the flood risk section of the PPG guidance. And the sort of starting point is your catchment area for search should be appropriate to the nature and scale of the proposal and the settlement. So one's first clue is that this is going to be a site-specific, context-specific analysis. And going into thinking about what questions asking about, look, for a non-major housing development, it would not usually be appropriate for the area of search to extend beyond the specific area of a town or a city, or beyond an individual village and its immediate neighbouring settlements. Now, but I suspect that where the particular line is drawn is going to need to be the subject of either agreement or argument, depending on what seems to be appropriate to context. And that's really all I've got to say about that, because that's all we've got from the guidance. Now, I'm going to, rather than hog all these questions, there's a question on the need for a reservoir. Is that overly specific, or is that one that, Richard, you'd be prepared to think about?
Yeah, I'm happy to talk to that. So I think it's an important point, sort of what's the relationship between these prior decisions about need for particular water resources. And as I say, I think similar issues arise for example, electricity transmission. What's the relationship between that sort of establishment of need elsewhere and then the detailed proposals? And I think it's right to say that there will be non-strategic elements for any proposal, such as site design and the extent of land take. But the boundary between those factors is not necessarily straightforward. So, for example, the scale of the water resource option that's required will be essentially defined in the water resources management plan in many cases. So if you're looking at a reservoir as the sort of easiest example, you're going to need to get a particular output from it, and that will determine questions about scale, and therefore issues such as design and land take may follow on from that. There may also be other matters that are dealt with in the water resources management plan that identify particular sources for reservoirs, which again may heavily influence design. So although the answer is yes, the water resources management plan is only identifying the strategic option or the set of strategic options in general terms, and the planning system is looking at the detail and how that's being designed, the two things are not hermetically sealed. And you do see in many cases, I think you'll see there's quite a lot more influence than just saying we need this many megalitres per day from this resource in this general location. I hope that answers the question.
There's an important cut across for the CPO context as well. You know, reservoirs, things like that, they all require, or generally all require, CPO. And your compelling case in the public interest with need established through your WMRP is considerably stronger than if it wasn't. So definitely not hermetically sealed, and not just the planning components of a DCO, but also, in my view, the CPO aspects as well benefit from that sort of strategic need being established.
Yeah, and then you get onto those really interesting points, don't you, Matt, about the relationship between what is said in national policy statement on need for and absence or assumptions about absence of alternative, and the extent to which you can reopen that at all in the context of a compulsory acquisition case when you come to a DCO examination. I know you were involved with the safe this case, but the same things happening not just in the water context, across energy as well, where there is potentially lines for argument about the extent to which you still need to consider compelling case in the public interest, or the extent to which you need to consider alternatives within that argument, given what's been determined already in water resources management plan or elsewhere.
Yeah, agreed. And same with the EIA. So the Water Resources, not NPS, talks about still looking at reasonable alternatives for the purposes of EIA, but to what real purpose if it's already been established that this is the need and this is the project? So difficult questions to work through.
EIA plus, sorry to add to it, but plus habitats plus Water Framework Directive, where alternatives may also be mandatory material consideration. So there's room for argument here about the lines between a strategic need case being established in the water resources management plan and what ultimately needs to be examined on the specifics.
Well, listen, thank you all of you for some really interesting and engaging presentations. I think rather than half answer any more questions, I think we can in fact answer them in writing afterwards. And it just falls now for me to thank all of you for joining us this morning for what I hope was an informative and useful set of presentations. We hope to see you at other landmark events in the future. Many thanks.